Let's break down the case a little bit further. And to do so, we turn to Rosa Freedman. She's a professor of law, conflict and global development at the University of Reading. Rose, thank you so much for joining us. In terms of this case, why is it such a benchmark, possibly hallmark case with the International Court of Justice?
Well, this certainly isn't the first time that the International Court of Justice has been asked to provide provisional measures, which is an early ruling on whether or not there may be a genocide occurring in Gaza. It did so recently in the case of Gambia and Myanmar to do with the Rohingya. But this is a benchmark ruling because, as we've seen, the UN Security Council has not been able to come to agreement on what should happen in terms of Israel and Gaza, both in terms of the war in Gaza against Hamas, but also in terms of the Israeli hostages. The General Assembly has passed resolutions, but they are not binding. And so the next step has been South Africa bringing this case to the International Court of Justice in what many see as a somewhat political move to try and get some form of ruling as to whether or not what Israel is doing in Gaza is in fact lawful under Article 51, its right to self-defense of the UN Charter, or whether what it is doing is not lawful.
And now take me through the process in terms of what the ICJ will be looking out for, what kind of arguments it will find in favor of either party to this case.
Well, the hearings today and tomorrow are really sort of the early hearings. These are to rule on what's called provisional measures. And this is because the International Court of Justice can take years or even decades to hear cases and to come up with a ruling where two countries have a case in front of it. Now, of course, where you have something like a war, you need to have some ruling on should there be provisional measures. And South Africa have put forward a number of these, but the one that the world really is taking note of is South Africa would like a ceasefire until such a time as the court can rule whether or not there has been what it alleges is a genocide in Gaza. Now, it's unlikely that the court can rule that there will be rule for a ceasefire as a provisional measure. Because, as I said, Israel has its absolute right, as all states do, to self-defense under the UN Charter. And that right comes over and above all other aspects of the UN's work. Remember that this World Court is actually part of the United Nations. But there are other provisional measures that the court may rule on after it's heard the South African case today, the Israeli response tomorrow. Over the coming weeks, we'll see whether the court says it is plausible enough that there are atrocities occurring that would require these provisional measures to be called for, while the court then takes the years or decades that it often takes to come up with its final ruling.
And then how is Israel basically going to respond? How do you expect it to respond tomorrow in its 3 hours?
Well, really, what this all boils down to is whether or not a genocide is being perpetrated. And a genocide is a very specific international crime. It is the worst of all international crimes. It requires not only the acts, but an intention behind those acts to destroy in whole or in part a group based on their nationality or their ethnicity, their religion or their race. What Israel will likely argue is that it is acting under self-defense to root out a terrorist organization that has at its heart in its charter genocidal aims against Israel. Well, I imagine that Israel will put forward a case that says this is not a genocide, it is a legitimate war, and that the Genocide Convention, therefore, cannot be invoked by South Africa on behalf of the Palestinians. And therefore, it will be pushing to not have provisional measures, and it will be asking for the court to say that if there are any provisional measures relating to the war, that it would also include the release of the hostages that were kidnapped on the 7th of October.
And given the fact that this court, as you say, is largely symbolic, it cannot enforce these rulings, what then are we really hoping for ultimately to come out of this?
I mean, I think it's important to note that this is the highest of all international courts. It's certainly not symbolic. But the way that international law works is that there are no enforcement mechanisms. You can't put a country into prison. You can't send the bailiffs around to enforce international rulings. So we rely on political enforcement as well. And certainly if Israel were to ignore any provisional measures, there would be serious political consequences at the international level. But we have seen that Russia, for example, has ignored the court's provisional measures. Myanmar has done. In fact, many of the provisional measures laid out over recent years and decades have been ignored by one or both parties. But it really will be for the international community to try and place pressure on both Israel and on Palestine if there are provisional measures that they need to implement.
Rosa, thank you so much for that insight. That's Rosa Freedman coming to us from the University of Reading.